This is the videotape deposition of Charlie Grapski in the case of McCoy et al. Versus City of Alachua, Florida. Case number 01-062839. Do know that 201 Southeast 2nd Avenue, Suite 207, Gainesville, Florida, on January 5, 2007, at the time indicated on the video screen. My name is Pamela Forlod, and I'm a court reporter. The videographer is Walter Johns in association with Square Associates, Inc. Principal now introduce yourself.
Robert Rush for the City of Alachua.
Joe Lovell for the plaintiffs.
All right, sir, you can raise your right hand, please. Do you swear or affirm that the testimony you are giving this matter be the truth, the whole truth, and nothing but the truth?
Station on the record.
My name is Charles Grapski.
Do you have a current residence?
Not currently. We went through this last time.
I know. This is an update. I just wanted to see if it changed.
No, it hasn't changed.
Since our last deposition, I've received information that you have further information regarding this lawsuit that we did not discuss. It's been alleged that you have evidence that testimony has been perjured in this case. Is that correct?
I have no idea what you're talking about.
Okay. Are you aware of the manufacturing of any evidence in this case?
I've watched the City of Alachua and your office manufacture evidence left and right, but I don't know what you're talking about.
Okay. Please detail for me what evidence you are alleging that my office has manufactured.
Which allegation are you referring to?
I'm referring to your allegation that you just stated.
Now you asked me if I've heard of any manufacturing evidence. I said I've been watching this case for, 8 months, 9 months now, and I haven't seen anything done properly yet. But if you have a specific allegation that you're referring to, go ahead and tell me.
Yes, I'm referring to the phrase manufacturing of evidence.
Okay, where did it come from? I don't know.
Well, you just repeated that, sir.
You asked me a question. I said, Rob, I've been watching you guys left and right do things.
Okay.
I wasn't referring to anything specific.
Okay. So you have no basis for that? Is that what you're saying?
No basis for what?
She's saying that my office is manufacturing evidence in this case.
Mr. Rush, I've seen your office sit here represent the City of Alachua and produce every document that existed in the City of Alachua regarding the elections, and I've seen you come back months later and present records that didn't exist months before. That I would constitute would be manufacturing of evidence.
Okay.
Which I think is probably problematic under the bar.
What records are you referring to, sir?
Well, for example, we know that the Willett-Dixon matter produced 2 ballots, one of which was destroyed, according to both Willett and Alan Henderson's testimony, and all the records that we had. In fact, I made numerous public records requests to see every document related to the absentee ballots. I was given those documents eventually after numerous difficulties. Then in deposition with your clients, we had every document presented, and we went through with your presence every single document, and there was no such thing as a spoiled ballot that was produced by Alan Henderson when Willett-Dixon cast her second vote. So I think that's pretty problematic that you've introduced that into evidence. I would say that that would constitute the manufacturing of evidence with your cooperation, and I think that's pretty serious.
It's very serious.
No, yeah.
You were there when Mr. Henderson testified, weren't you?
I was, and that document was not there.
And you're aware that Mr. Henderson in his deposition was never asked to produce that document?
Sure he was. He was asked to produce all the documents, both by me on numerous occasions, by Mr. Canning, and under subpoena by Professor Little.
Let me read you from the deposition of Alan Henderson, dated August 24th, 2006, page 10, where Mr. Little asks, this is not a page 10 starting on line 5. This is not a spoiled ballot. It's my understanding it's a spoiled ballot. Yes, on people like Dixon. You gave that person a new ballot and the person voted. Is that correct? That would have happened. Yes. And you tore up the other ballot. Mr. Little's question, answer. Tore or put it in the absentee ballot miscellaneous box. I don't remember.
Can I see that?
Sure can.
Under law, if you haven't researched it, A spoiled ballot.
I'm here to answer.
I am answering your question. I'm answering your question.
You can look at that
I'm answering your
document.
question.
You can look at that document, and I've got another question.
Right, and I'm answering the question you just asked me. So while I'm looking at this, I will ask you. A spoiled ballot, by definition, is a ballot prior to being cast, which has an error or what won't work, and that there's a whole set of legal procedures whereby that ballot must be retained and placed into a sealed spoiled ballot envelope. There was no such thing as spoiled ballots. There were no spoiled ballots reported to the canvassing board. There was no spoiled ballots in the records. There was no spoiled ballots in the box of every single document that your clients produced with your cooperation on the day of this deposition. There was no spoiled ballot, whether you want to redefine it as such or not. Now, what is stated in this is that, oh, I tore it up, which is what he originally said, and what Willett Dixon testified, and what Willett Dixon stated to Michael Candy, myself, and about 10 other individuals, or I put it in the absentee ballot miscellaneous box, of which we've never heard, never been produced. There is no such technical thing under the law, miscellaneous box, which certainly wouldn't constitute a spoiled ballot envelope in the first place. No. So whether you want to call it spoiled or not, it's not a spoiled ballot. What it is a ballot that you have manufactured that has no chain of evidence, that just appears out of nowhere, that says, I assert that this is the ballot that Willett Dixon first voted. Doesn't solve the problem because that's not a spoiled ballot under the law. Willett Dixon was still allowed to vote twice, only because she came out, spoke to Clovis Watson, and then went back in to find out which of the two Lewises that she's never heard about she was going to vote for. Seems to me like you've got a problem, Mr. Rush.
No time during Mr. Henderson's deposition was he asked to find and produce the absentee ballot miscellaneous.
Because there was none. Meaning, we sat there with the entire set of subpoenaed documents, and we went through document by document by document. I made sure of that because if you remember, despite your objections, your attempt to claim that I wasn't legally allowed to be there, I was able to be present physically at the Allen Henderson deposition. And at one point I said I wanted to see what was in that box. And we went through document by document by document. And at not one single time was there an absentee ballot miscellaneous box produced. Was there a spoiled ballot for absentee ballots produced? Was there an envelope for spoiled ballots for absentee ballots? However, you will recall that there was a spoiled ballot log for every single precinct, but there was nothing for the absentee ballots. That thing has been manufactured out of thin air, and you have entered it into court, I assume, to try and create an ad hoc justification for your clients, which I find highly problematic, Mr. Rush.
What's the relevance of whether or not he produces the ballot that was not counted for the Willett Dixon?
Because you're trying to create for your clients, as a defense, a series of, well, here's the actual facts that happened. Let's come up with an alternative explanation to present to the judge. And you're trying to manufacture evidence, in my opinion, to help your clients get off of a case in which they committed numerous improprieties as well as criminal actions. I find that to be reprehensible, Mr. Rush. I have lost all respect for you in that.
The encouragement of perjury. Are you aware of me encouraging anyone to do perjury, Mr. Grapski?
I would say when you entered into the court record that document, and when you referred to the court as if that document solved the problem that you had with that evidence, you were encouraging and participating in perjury by the city of Alachua. And you are a city of Alachua official, by the way. So I would say that that puts you in a very significant problem.
You're aware that the city of Alachua produced in response to the plaintiff's third request for production the base-numbered ballot of Willett Dixon.
No, I am aware that you produced out of thin air some ballot that we have no idea where it came from, that was never presented when I requested under Florida Public Records Law, Chapter 119, on numerous occasions for every single absentee ballot-related document that still was in existence. I was told that I was given access to every single document except those that were assimilated back into the earth or destroyed. That ballot did not exist. That ballot has appeared